Cool. I'm gonna give it a few seconds.
You on YouTube?
I am on YouTube, yes. I'm gonna wait for some people to join in.
I'm gonna go share.
All right. Peace. So, I think it was Monday, right? Monday we went to the post office? Yeah. So Monday I uploaded that video of us at the post office proving that I did in fact send these documents to Gabrielle R. Perlmutter, who's the assistant DA, right?
Yeah.
The assistant DA for Rhode Island. No, she's the special assistant to the DA. And her father have Perlmutter LLC law firm in Cranston.
Assistant to the regional manager.
So I sent this to Gabrielle R. Perlmutter, Perlmutter, who's an active member of the Bar Association, who's the acting prosecutor for this case right here, 61-20-2734. I also mailed this to the court, the 6th District Court of Rhode Island. I addressed it to Terrence, Terence, J. Houlihan, Houlihan, Jr., who is the acting magistrate judge on this case. I also found out that he has a firm in Newport, Rhode Island, which in order to have a law firm, you have to be part of the bar. So both of them are part of the bar. You'll see I attached the evidence into these affidavits. Right, so this was the last document that I sent in order, but it's the first that's right here, so I'm just going to read it. So this is a conditional writ of discovery that I sent to the courts. You'll see here where I state that the reason why it's conditional is because my previous affidavits prove that they don't have jurisdiction, but if they still want to railroad us like they normally do and proceed unlawfully and unconstitutionally, then these are the things that I want. If you're going to act like you're lawful, then these are the things that I want. So if you want to play the game, I'll play the game, but just know I'm way better at the game than you are, so you might want to just dismiss the case. But anyway, so it starts off, as you can tell, this is the first affidavit that I did in the previous video when I stepped into the courtroom under a special appearance, and the magistrate said that he was reading this. I read that in the earlier video, earlier last week or the week before that, so check that out. But obviously the disclosure statement is shorter because based on what he said as I was leaving, you'll hear me reference Sundry Fee Morse Act, so I put that in here so they can't play stupid. But anyway, I'll just read. So this instrument, sorry, I'm reading here. This instrument is not to be mistaken as a submission to the jurisdiction of the state. See Sundry Fees Morse Act of 1790, Journals of the House of Representatives, State Records of South Carolina, published for the South Carolina Department of Archives, and History by the University of South Carolina Press, page 373 to 374. The petition of the free Moors, so you see that? I'm claiming to be a Moor. No law of this state, meaning South Carolina, can in its construction or operation apply to them, meaning the Moors, and that persons who are subjects of the Emperor of Morocco, being free in this state, are not triable by the laws of the state. So that is not to say that we are above the law. That is to say that we can only litigate in federal courts because we're not U.S. citizens. So this is not to avoid justice. This is me putting the courts on notice that they lack subject matter and personam jurisdiction. So this issue must be litigated in federal court. So again, this is not trying to avoid justice. This is me telling them this is the wrong venue. Just like if you go to Burger King, you try to order a McDouble, that's McDonald's. You're in the wrong jurisdiction. You can't ask for McDoubles at Burger King. Wrong venue, wrong jurisdiction. Same thing for the courts, right? Nor is it proof or evidence of the recognition to the validity of any alleged claims or complaints made by the plaintiff. This is solely, strictly, and only for the purpose of Jamal Talib Abdullah Bey to remain in honor and to maintain his innocence, which if you look up the counterintelligence program of the FBI, you'll see that one of their tactics is to give people criminal records if they don't have one, by doing false arrests, serving illegal and unlawful warrants, and things like that. And if you don't believe me, look up Karen Bass, Representative Karen Bass, who's a current Congresswoman right now, addressing the Attorney General, Jeff Sessions, whatever his name is, on the counterintelligence program of the FBI. If you don't believe her, look up Barbara Lee, who's also a representative, a representative of Congress right now, who also addressed the House of Representatives dealing with the counterintelligence program. If you don't believe her, look up Representative, I don't know how to say her first name, Representative Omar from Minnesota. She's the Muslim woman who addressed the House of Representatives dealing with the assassination of Fred Hampton by the Chicago police in collusion with the FBI. So look it up. As stated, so that's a typo, which means you can make mistakes and it doesn't change the validity of your documents. As stated in the journals of the House of Representatives of South Carolina, since the decision was made pursuant to Article 3 and 6 of the Constitution, Moors are not subject to either civil or criminal proceedings of the state, as there is a standing treaty between our Moorish government and the United States. See the affidavit of fact and writ of dismissal filed with the courts by Jamal Talib Abdullah Bey, signed the 3rd day of Shaban in the year of Allah 1441, which is this document right here, which is what Terrence J. Houlihan was reading as I walked into the room. I will also at times be referring to myself in the third person as opposed to saying my, which in this instance, when I refer to myself in the third person, it is to be taken in the context that I know I'm writing for, of, and about myself. It is also written this way to display my ability to be objective and honor all applicable federal and treaty laws, as this issue does not just affect me, it also affects the Moroccan people. So again, our prophet said, all living things are bound together by cords, right? There's also res judicata and stare decisis that states that when one person is enforcing the Constitution, he's not doing so for himself, he's doing it for the people as a private attorney general. So this doesn't just represent me, know that. Right, so now we're going into the facts. Number 1, this instrument is entitled Conditional Writ of Discovery to compel the opposing side to offer any and all information regarding this issue and specific information regarding this issue in the event that the court, via the unconstitutional decision of the biased justices or magistrates, continue with this case in violation of Article 3 and 6 of the Constitution, as well as 28 U.S.C. 1331, which is dealing with the federal question, and 28 U.S.C. 1332, which is dealing with diversity of jurisdiction, which falls into Article 6 of the Constitution, which states that this Constitution and all laws made in pursuance thereof, which would be the USCs, shall be the supreme law of the land, and any laws of any state to the contrary notwithstanding, as well as any and all other issues brought up by Jamal Talib Abdullah Bey that cannot be disputed without warring against the American people. So that's why I'm doing the discovery under these conditions, that you're warring against us, which they are. And the people aren't doing anything about it. Number 2, discovery. Pursuant to the law, both federal, civil, and criminal procedure, the Constitution, state laws, and statutes, since, again, this is conditional, so if you're going to violate my rights, I'm going to at least fight, right? Since my people don't want to do anything about it, I have to fight by myself. I hereby demand that the prosecutor release any and all information specifically highlighted pertaining to this case as per individual request, to include but not limited to. Now, before I get into that, I said specifically highlighted because they're not about to give me 20 pages of documents and I'm not about to skim through it. You're going to highlight and then I'm going to skim through it. So do the work for me because that's your job, because I'm asking for it under discovery. So you got to abide by it. A, video footage of the Rhode Island State House whereby Julissa Amora Adonai El, and then ex-rel Godbout, because that's what they're trying to call her, that's not her, allegedly assaulted several state troopers in the State House, was able to leave, then enter through security again without being arrested while there are approximately 5 state troopers in uniform with several civilians recording. Because the reason why the police showed up to my house is because an alleged warrant that took place stating that Julissa attacked 3 state troopers in the State House. So show me video footage of that, because there was about 5 of them, and I'm lowballing because I already know there was more. B, the original certified original copy of the warrant signed by a judge that was allegedly presented by the police, because in their own police narrative, they said that they showed me a warrant, which I never saw a warrant. I just called it that because that's what they said, and I said I never seen it, which I already addressed. Oh, yeah. Sorry, I forgot about that. I'm reheating some mac and cheese and I forgot. It's vegan. C, writing in the warrant that states the police can enter the home or property listed in the warrant and tamper with the recording system installed into and on the home. As I stated before in my previous video, which I showed you, I have a security camera system in my house. Well, the system's in my house, but it records the front door and the exterior of my house, which is where the alleged police showed up. And we would have been able to see the bait and switch that they did if they didn't come in and tamper with the footage, both on the iPad and on the actual camera system itself, which once we got released from prison, I seen the camera system was messed up. It was fuzzy, but I fixed it, right? D, writing in the warrant or any laws that states the police can delete recorded footage of them breaking down the door to the home after they unlawfully arrest the persons recording them. Because as you'll see in my affidavit, Julisa's affidavit, and Moreno's affidavit, we all can and will testify that Julisa was recording up to the point in time where we stated in our affidavit that she was recording. And then they took her phone allegedly as evidence and took the iPad allegedly as evidence, but they never logged it in as evidence. Also, specify in writing what anti-police rhetoric is as written in the police reports or narratives of the several alleged policemen. So let me show you that real quick. Because part of the fake discovery that they gave us, which is insufficient, several of the alleged state troopers stated that I use anti-police rhetoric, which they're gonna have to specify what that is. And I'll just keep that information to myself. All right, so let me hide this. Let me hide that. All right. All right, so this is gonna be hard to show because I have to hide a bunch of personal information, but that says expressing anti-police rhetoric right there. And this is from the, you see that Rhode Island State Police Headquarters narrative for Detective Andrew Emerson, right? And a bunch of these state police said the same thing in their affidavits because they have no originality. And I got some, they also made a mistake in the report, which I'm very excited about.
Where? Hold on, point.
Remember the address that they gave us?
That's not a mistake.
What you mean that's not a mistake? That's a gift. That's a gift. But anyway.
And the title?
Anyway. All right, so they have to specify in writing what this is. And don't worry, don't fret. The attorney, prosecutor already got this information, so it's not like I'm revealing this ahead of time where, oh no, I just destroyed my whole argument. This is all public information. It's supposed to be a public and open trial anyway, which it is not. So they're already violating not just my rights, but your rights too, because if they can do it to me, that means they're going to do it to you. And if you're not in an uproar about it, I feel bad for our people and everyone in general, because whatever. I'll just continue. F. Provide video, audio script, writing, logograph, or other visual or phonographic evidence of Jamal Tlaib Abdullah Bey expressing in full context his alleged anti-police rhetoric as written in the police report or narrative of the several alleged policemen. Note, it is stated in the narratives provided by the prosecutor that the police have viewed Jamal Tlaib Abdullah Bey's YouTube channel and they are therefore able to provide the requested video, audio, or other media forms of Abdullah Bey expressing what they call anti-police rhetoric. G, provide any and all information that has been briefed to the state police from the agency itself or any other agency to include but not limited to the FBI regarding the Rise of the Moors organization. As stated in the police narratives, information was relayed to the members of the Violent Fugitive Task Force, that's what that means, which I have no history of violence. I have no history of being a fugitive, so why they send the Violent Fugitive Task Force to my house regarding aligned members of a sovereign movement called Rise of the Moors, which is, this is what they said, informational briefs regarding the Rise of the Moors movement, all right? Also specify which agent and which agency provided said information and specify if the Rise of the Moors and its members are listed on the FBI's Black Identity Extremist list, as well as proof that any officials of the Rise of the Moors has referred to themselves as a sovereign movement, or expressed that they think that the federal laws of the United States does not apply to them, despite the members going to federal court to file claims, with various newspapers proving that they go to federal court and abide by federal laws, as well as cases with dockets in federal court of Rhode Island and the federal courts of appeals, which I attached newspaper articles from not only New Hampshire, but from Providence, Rhode Island, specifying that we go to court and we're not anti-constitutional and we don't go to war with nobody. We go straight to court, which I attached that in this affidavit and gave it to the prosecutor. So they're biting their own, they're going to have to eat their own words. H, provide medical records and or images of any bruises sustained from the alleged push or other assault on any state troopers as claimed in the police narratives, proving that there is an injured party and statement of claim upon which relief may be granted. I, provide information in regards to whether or not the police know what a bait and switch is and specify if using said tactics fall within the scope of police conduct. J, provide information regarding police conduct in regards to them showing up to a dwelling, home, property, domicile, or residence in civilian clothing, being sufficient enough to clearly identify a police officer. Also provide information that clearly shows that it would be impossible for a criminal to acquire a badge, dress in civilian clothes, and knock on a person's door claiming to be police without a warrant in their hands while claiming to have a warrant. Also provide proof or evidence that it would be impossible for a criminal to obtain a copy of a warrant or fabricate a copy of one and try to serve it, which according to their own police narrative, once we asked for a warrant, they told one of their people to run across the street to go get some documents, which means they did not, they admit in their own police narrative that they did not, and more than one of them, that they did not show up to the door with a warrant. And that once we asked, even though they said they had one, they did not show up to the door with one. So that better fall within police conduct. They better fall within police conduct because that's what they did. K, provide any and all information on any informants used in the service of this alleged warrant. If a Darden hearing is required, it is lawfully demanded, and look that up. If you don't know what that is, look it up. It is lawfully demanded that we either attend or view the unredacted transcripts of said hearing. Also provide any and all probable cause that gave warrant, cause, or reason for the Rise to the Moors organization and its members to be investigated, clearly identifying the violation of laws conducted by said organization or its members. M, provide a list of names and addresses of any and all claimants or injured parties as a result of the issuance of the warrant, and the same information for the alleged assault victims that allegedly sustained injuries in the Rhode Island State House, as well as images or medical records of said injuries and the police reports filed by said alleged injured party, along with the default notice and summons issued to the alleged assailant to have a hearing regarding said alleged assault, with proof of service, as this is needed to determine the validity of said warrant, which resulted in the police causing $6,000 worth of damages to the listed defendant's property. N, provide any and all video or audio recordings of all parties listed in the police narratives and police custody, and video and audio recordings and documents of the same listed parties, where they were taken to prison, given inmate ID numbers, forced into a machine that provides warning that it causes radiation, and all video and recordings of all personnel and the listed parties in the police barracks, to include all retina scans, fingerprints, handprints, DNA samples, photographs, reports, and the like of the listed parties in the police narratives, including but not limited to any and all legal or illegal surveillance, wiretaps, bugs, or the like. And then under penalty of perjury and prosecution from the Moorish nation, I do declare and state for the record, to the best of my ability, with a sound mind and with a sound and conscious mind and heart, without malice intent, that all claims and statements made in this instrument are true, factually and lawfully based, and not made for nor intended to be used for fraud, misrepresentation, misprision, nor usurpation. It is furthermore stated and affirmed that all statements made are made in pursuant to and respect for the federal, constitutional, and treaty laws of the United States and the natural, ecclesiastical, civic, theocratic, and national laws of the state of Morocco, a free Moorish American national and citizen of the free national government of Morocco. I am, my signature or autograph, whatever you want to call it, all rights reserved and retained in honor of my Moabite ancestors to time immemorial, exercising the divine and common law right to just post-limine in accordance with the high principles of love, truth, peace, freedom, and justice as commanded by my holy prophet and guide, El-Hajj Sharif Abdullah Ali, Noble Drew Ali. I affix my autograph / signature here too. And that's page 6 of 6. And this was the second affidavit that was supposed to be filed. So it's in reverse order. So that's the last one that they got if they didn't honor this one and the one next. So this is considered a judicial notice, affidavit of fact concerning a conflict of interest and writ of dismissal based on the right to speedy trial. I'm not going to read this because it's the same disclosure statement that I read in the other one. So I'm just going to go straight into this. Number 1, federal law. Pursuant to 28 U.S.C. 455, disqualification of justice, judge, or magistrate judge, and the AmericanBar.org, since the prosecutor, judge, magistrate, and state police are all employed by the same entity, both the prosecutor and judge or magistrate must disqualify themselves. To avoid this issue, the federal Constitution stated that Article 3 deals with the federal courts having jurisdiction over issues between states and their citizens, and issues between states and citizens of a foreign state, which I am a citizen of a foreign state. So even if they did claim that I was a citizen of the United States, they would still have to go to federal court. Read Article 3, Section 1 and 2 of the Constitution, and you'll see that to be true. So this affects Europeans too, not just Moors, but, you know, keep listening to Virgo Triad and see how far you get in life. Furthermore, the judge, magistrate, or prosecutor must also disqualify or recuse themselves, as they are all part of the BAR, which is the British Accreditation Registry, which this is not Britain, which is an association that has membership. Therefore, since the judge or magistrate has a personal bias regarding members of his/her organization to which they are also a member, it would be impossible for anyone to have an absolute, fair, and impartial hearing, trial, or other administrative process with this type or form of potential to a bias based on mutual membership. This mutual membership leads one to reasonably raise the question of both the prosecutor and judges or magistrates' impartiality. Furthermore, as stated by the AmericanBar.org, the prosecutor should know and abide by the ethical rules regarding conflicts of interest that apply in the jurisdiction and be sensitive to the facts that may raise conflicts of interest. So not only does the judge have to recuse themselves, but so does the prosecutor. If either the prosecutor or judge or magistrate is an active member of the bar, they must disclose such information and properly remove, recuse, and or disqualify themselves from this issue. Information regarding Rhode Island bar members can be found on ribar.com. A search of Gabrielle R. Perlmutter, that's the prosecutor, clearly shows that she is an active member of the bar from the city of Cranston with a firm named Perlmutter Law Offices. An online search of Terrence J. Houlihan Jr., which is the so-called judge, the listed judicial officer of the arraignment, show that he has a law firm named Houlihan J. Terrence, Houlihan Manigan, and Kyle LLP with the phone number of 401-846-7777, located at 2 Marlborough Street, Newport, Rhode Island. In order to have a law firm in Rhode Island, you must be a member of the Bar Association. Thus, pursuant to 28 U.S.C. 455, Mr. Houlihan must disqualify himself, which this is dealing with the referenced United States Code. Any justice, judge, or magistrate of the United States shall disqualify himself in any proceedings in which his impartiality might be reasonably questioned, which it's being questioned right now reasonably. B, he shall also disqualify himself in the following circumstances. 1, where he has a personal bias or prejudice concerning a party. It was evident that Mr. Houlihan Jr. has a personal bias towards Gabrielle because when Jamal Talib Abdullah Bey asked the prosecutor for her name, Mr. Houlihan was able to spell her name for Abdullah Bey from memory. This clearly shows a personal bias, which if you don't believe me, you don't have to, because I recorded the entire proceeding. It's on YouTube already. Where I asked, is this the prosecutor? And I said, is this her? Talking about the prosecutor. And Terrence J. Houlihan said yes. And I said, what is your name, ma'am? And he said what her name was. Then I asked again. And then a bunch of people said what her name was. And I said, I'm sorry, I can't hear you. Then he spelled it out for me, which he would not be able to spell my name. Why? Because he does not personally know me, which means he has a personal bias towards her. Huh?
I was going to say, kind of emphasize, because it honestly took me a little while to understand the conflict of interest there.
Okay, there's a conflict of interest because, one, they're both part of the same organization. So obviously, if you're members to an organization, your loyalty is to each other. It's not going to be fair. That's why I'm saying that.
Yeah, I was saying that.
Yeah. Two, if you don't know someone personally, you're not going to know how to spell their name. So obviously there's a personal bias, which means if this judge who's supposed to be impartial knows how to spell someone's name off memory, you're not impartial. There should be no confusion on that. Just like when I was in the military and I had Marines under me, I knew how to spell their names. How to spell their names. Why? Because there's a personal bias. I'm directly in charge of them. Which, I'll tell you right now, in the Marines, a lot of stuff gets swept under the rug to avoid the entire platoon getting in trouble. Because if the platoon gets in trouble, then the battalion gets in trouble. So now if the prosecutor messed up, that reflects the state. If the police messed up, that reflects the state. If the judge messes up, that reflects the state, which all of them work for the state. So it would be unfair if all of them work for the state and the state's bringing charges against me and then the state's going to hear its own, determine its own guilt or not. That's impossible. Right? 2, violation of my constitutional right to a speedy trial. Not only has the amount of time from the arrest of 3/4/2020 to the pretrial conference of 5/15/2020 passed the Congressional Act regarding the right to speedy trial of 70 days violate this act by 2 days, the scheduled trial date of 5/29/2020, so that's when we have the other date, will pass this Congressional Act by the trial date falling on the 86th day. Furthermore, in addition to Jamal Tlaib Abdullah Bey's right to a 70-day speedy trial upon indictment, he has also not been indicted by a grand jury, meaning this case must not only be dismissed for violation of the right to speedy trial and a lack of prosecution, but also the failure to issue an indictment to Jamal Tlaib Abdullah Bey by a grand jury is also a violation of due process, and again, as in other instruments filed with this court, raises the federal question regarding the Bill of Rights. Be it further stated that an alleged pandemic, national or state emergency, or state of emergency does not suspend, make void, or nullify the Constitution. See this case right here. This is dealing with laches. The doctrine of laches is based upon a maxim that equity aids the vigilant and not those who slumber on their rights. Neglect or omission to do what one should do as warrants presumption that one has abandoned right or claim. Eldridge versus Idaho State. Then, Marbury versus Madison. No provision of the Constitution is designed to be without effect. Anything that is in conflict is null and void of law. Clearly, for a secondary law to come in conflict with the supreme law was illogical. For certainly, the supreme law would prevail over all other laws, and certainly our forefathers had intended that the supreme law would be the basis of all law, and for any law to come in conflict would be null and void of law. It would bear no power to enforce, it would bear no obligation to obey, it would purport to settle as if it had never existed, for unconstitutionality would date from the enactment of such law, not from the date so branded in an open court of law. No courts are bound to uphold it, and no persons are bound to obey it. It operates as a near nullity or a fiction of law. If any statement within any law which is passed is unconstitutional, the whole law is unconstitutional, by Marbury versus Madison. And of course, 5 U.S.C. subsection 556 D, section 557, and section 706, courts lose jurisdiction if they do not follow due process of law. Title 18 U.S.C. subsection 2381, in the presence of 2 or more witnesses of the same overt act, which there's 3, or an open court of law, if you fail to timely move to protect and defend the Constitution of the United States and honor your oath of office, you are subject to the charge of capital felony treason, which I posted the proceedings on YouTube. So the people might want to start reacting because this person's clearly violating his constitutional oath and the people aren't doing anything about it, which means what? He can get away with it. All right? American Jurisprudence Book 16, constitutional law, Section 97, states, then a constitution should receive a literal interpretation in favor of the people. It is especially true with respect to those provisions which were designed to safeguard the liberty and security of the people in regard to person and property. See Barry versus United States. Any constitutional provision intended to confer a benefit should be liberally construed in favor in the clearly intended and expressly designated beneficiary, which would be the people. While an emergency cannot create power, and no emergency justifies the violation of any of the provisions of the United States Constitution or state constitutions. Public emergencies such as an economic depression, for especially liberal construction of constitutional powers, which you'll see where they state that the COVID-19 caused this economic depression that we're in. So it doesn't matter if they want to call it an economic depression or COVID-19. They stated online that COVID-19 caused the economic depression, so there's no win-win for them. Right? Constitutional powers, and it has been declared that because of a national emergency, it is the policy of the courts of times of national peril so liberally construed the specific powers vested in the chief executive as to sustain and effectuate the purpose thereof, and to that end also more liberally to construe the constituted division and classification of the powers of the coordinate branches of the government, and insofar as may not be clearly inconsistent with the Constitution, which simply means no emergency has just cause to suppress the Constitution. Therefore, this issue must be dismissed for violation of due process, which is a violation of the Constitution. Then I signed under penalty of perjury again, so I'm not going to read that again. And this is the final, well, this is the first affidavit in sequence dealing with a judicial notice, affidavit of fact concerning my citizenship and writ of dismissal. I'm not going to read this disclosure statement because it's already on the first one, so just rewind it. Number 1, status. As previously stated and never rebutted in my previous filings and verbal/oral statements and declarations to the court, I, Jamal Tlaib Abdullah Bey, am a citizen of the state of Morocco, which the state just means people, so I'm a citizen of the people of Morocco, and all my allegiance belongs to Morocco, which means the people of Morocco, and not the United States, which means I'm not a citizen of the United States, which pursuant to 8 U.S.C. 1481, even if it was assumed I was a U.S. citizen, based on my declaration of allegiance, I am not a U.S. citizen, so now look up 8 U.S.C. 1481. I will continue to honor the treaty between my country and the United States until I am given no other option, as required by my religious belief, see the Quran, and my civic and military duty to my country. Noble Drew Ali was a prophet and a general, right? So that means I'm his warrior, so don't get it twisted. As stated previously, and standing as supreme law of the land, since I am a foreign citizen to the United States, I'm not foreign to the land, I'm foreign to the European corporation. This issue must be litigated in federal court with counsels from my country and yours present. See Article 3 of the Constitution for the United States of America of 1791 and Articles 20 and 21 of the Treaty of Peace and Friendship, Amity and Commerce of 1786, 1787. The prosecutor is barred from alleging that I am or have ever been a citizen of either the United States or the state of Rhode Island, which based on an alleged driver's license bearing the image of someone who may or may not resemble me or otherwise for the following reasons. A. Pursuant to the United States Justice Department Criminal Resource Manual 1508, as mentioned in the previous filings and never rebutted or rejected, standing as judicial notice, nor can it be rebutted or rejected without going against the United States Justice Department. A driver's license is not identification and is not described within 18 U.S.C. 1028, which fails to adhere to federal law in violation of Article 6 of the Constitution and does not meet the requirements of a Real ID as defined in the Real ID Act of 2005, which specifically mentions and is governed by 18 U.S.C. 1028. B. All just solely or just sanguine naturalization or acquisition of U.S. citizenship laws are based on the 14th Amendment. See nl.usembassy.gov. The 14th Amendment of the United States Constitution guarantees citizenship at birth to almost all individuals born in the United States or in U.S. jurisdiction based on just solely. and law.cornell.edu, the 14th Amendment addresses many aspects of citizenship and the rights of citizens. Therefore, the prosecution in the state, as well as any and all other parties, direct or indirect, are barred from asserting or making the claim that I, Jamal Tlaib Abdullah Bey, or the fictitious name, Jamal Latimer, or any other names or identities, any parties trying to force on me, is, was, or has ever been a citizen of the United States or the state of Rhode Island, based on the proceedings of and debates of the 90th Congress, First Session, Volume 113, Part 12 of June 12, 1967, Congressional Records, page 15641, et sequa, which states the following. The 14th Amendment is unconstitutional. The purported 14th Amendment to the United States Constitution is and should be held to be ineffective, invalid, null, void, and unconstitutional for the following reasons. 1. The joint resolution proposing said amendment was not submitted to or adopted by a congressional Congress. Article 1, Section 3 and 5 of the U.S. Constitution. Number 2, the joint resolution was not submitted to the President for his approval. Article 1, Section 7. And number 3, the proposed 14th Amendment was rejected by more than 1/4 of the states then in the Union, and it was never ratified by 3/4 of all the states in the Union. Article 5. So even if they claim that I'm Jamal Latimer or any other name that they want to call me, they can't say that I'm a U.S. citizen based on the 14th Amendment because I just showed you that it's unconstitutional. It is also reaffirmed that I cannot be, nor ever have been, a U.S. citizen or a citizen of the United States or the state of Rhode Island pursuant to the 13th Amendment, Section 12. See the Congressional Globe containing the debates and proceedings of the first session of the 38th Congress, which state the following. Article 13, Section 12. The traffic in slaves with Africa is hereby forever prohibited, and the descendants of Africans shall not be citizens. Number C, in reference to the statements made by the magistrate or acting judge of the unlawful proceeding that occurred on the 15th day of May 2020 in Room E regarding the historical accuracy of the information presented, it was noted by said person, colored as a judge, that the historical information is and was accurate. No statements were made disputing the lawful or legal standing of any arguments made. Therefore, all historical and lawful claims made by Jamal Tlaib Abdullah Bey stand in law, especially with reference to Article 4, Section 1, of the United States Constitution, which states that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. D. Pursuant to the AmericanBar.org, a prosecutor is an administrator of justice and an officer of the court, and like the court's officials, he or she must adhere to and abide by all general and specific laws and both public and private statutes of the United States, and give respect to any and all proceedings and debates of Congress and public records of any state, especially as it pertains to the issues of diversity, nationality, and citizenship in this case. As mentioned by the magistrate or acting judge of the unlawful proceeding that occurred on the 15th day of May 2020 in Room 4E regarding the issue and proof of my nationality, is a preliminary issue. Subsequently, no trial can take place as to the material facts of this case, as the issue of status must be addressed, and pursuant to corpus juris secundum, issues of law supersede issues of fact. Which this came out of the so-called judge's mouth, which, if you don't believe me, go to the recordings that I took. It's on YouTube. I'm pretty sure it's titled Today's Court or something like that. It's a few days ago. You'll see where he said, give me your nationality card. That's a preliminary issue that we have to go over. So we can't even go to trial until he addresses that, which that's next week. Right? Where was it? I'll just read it again. Pursuant to corpus juris secundum, issues of law supersede issues of fact. Therefore, supporting Jamal Tlaib Abdullah Bey's claim of diversity as assertion of federal laws and challenging of the state court's jurisdiction, which it lacks and still has yet to prove and is unable to prove without warring against the Constitution, the United States, and Morocco. E. Supporting and reaffirming the above listed statements, according to AmericanBar.org, the prosecutor should seek to protect the innocence and respect the constitutional and legal rights of all persons, including suspects and defendants, which Jamal Tlaib Abdullah Bey has clearly shown how the issue of diversity is primal, is governed by the Constitution, and the proceedings of the state over his person is a violation of his constitutional rights and a violation of 28 U.S.C. 1331, 28 U.S.C. 1332, and Article 3 Section 1 and 2 of the federal constitution. Number 3, lack of jurisdiction of the state. No judge or magistrate being a public servant deriving their power from the people via the constitution appointed or elected has a power to determine their own jurisdiction. As the jurisdiction is already delegated in both the federal and individual state constitutions, as well as any other amendments or additions made by their respective legislators. Therefore, judges lack the discretion to determine their own jurisdiction and must adhere to both federal and state laws and delegated authority. Thus, once challenged, jurisdiction must be proven, which, in this case, based on the raising of the federal question and the prima facie issue of diversity, no state judge or magistrate will ever be able to prove jurisdiction on the record over treaty issues which have been raised, federal constitutional issues which have been raised, or diversity of citizenship and or diversity of nationality issues which also have been raised. There is furthermore no need to continue to provide res judicata, stare decisis, or case law to further support this claim, other than what has already been previously recorded and stated verbally or orally, as the Constitution stands by itself, and truth needs no support or apology. It is also declared that officers of the court are barred from claiming ignorance of the law, as they are bound to know law. See previous affidavit regarding the facts of law as to why the issue must be dismissed for lack of jurisdiction. The state is furthermore barred from giving me or forcing upon me an identity or nationality. See United Nations Declaration on the Rights of Indigenous People, on Human Rights and the Rights of Indigenous People regarding our right to a nationality, the right to self-determination, the right to self-govern, the right to not be arbitrarily deprived of our nationality, and the rights to enforce our treaties, as well as the state's obligations to recognize our political status, which is derived from our nationality. See Henry Campbell's Black's Law Dictionary, 4th edition, regarding the definition of nationality and how it determines one's political status, especially with reference to one's estate and their ability to enforce one's rights, as well as one's right to have rights, as well as the definition of the word Negro being defined as a black man, stating that black men are colored persons, and that there is no legal technical signification to the phrase colored person, which the courts are bound judicially to know, and its reference case law, as well as the definition of civiliter mortuus, which means dead in the eyes of the law, i.e. black and colored persons are dead in the eyes of the law since they have no nationality. See Peoples versus City of Detroit, 344, which if you go to caselaw.findlaw.com and type in Peoples versus City of Detroit, you'll see where 11 firefighters were laid off. One of them made a claim that they were discriminating against him because of his national origin. The other idiots claimed discrimination because of race, and the courts determined, this was federal court, the courts determined that the only person that had right of claim, the right to sue, the right to do anything in court, was the person that claimed discrimination against his national origin. It is also asserted that a judge or magistrate role is merely to administer, hear the facts, and make a decision based on the law after hearing the facts and issues presented by both sides. Since all arguments made by Jamal T. Abdullah Bay raised the federal question and issue of diversity, the acting judge or magistrate has no choice but to dismiss this case based on lack of jurisdiction or issue an order, in order to the opposing party to remove this issue, as stated before, to federal court. The statements do not waive Jamal T. Abdullah Bay's right to raise the issue of violation of his right to speedy trial. Then number 3, accuser bears a burden of proof. Proof of claim attached is a copy of my nationality card, to which I am not obligated to prove my nationality, as the accuser bears the burden of proof and must prove that I am a citizen, which they cannot. I am merely providing this as a courtesy and have been making special appearances to the state court in fear of my life of unlawful imprisonment, as I was already thrown in prison by this court. This nationality card stands as third-party evidence, as I did not produce it, and stands as proof of my nationality and citizenship. Note, I have purposely hidden my private mailing location on the ID. Number 4, judicial notice. All statements made in regard to treaties, constitutions, proceedings, and debates of Congress and the like are mandatory judicial notices and cannot be disputed. Therefore, all claims made thereon cannot be disputed, and this issue must be dismissed. Judicial notice, Henry Campbell, Black's Law Dictionary, 4th edition, page 986. Without the production of evidence recognizing the existence and truth of certain facts having a bearing on the controversy at bar, which, from their nature, are not properly regarded as testimony, or which were universally regarded as established by common notoriety, e.g. the laws of the state, international law, historical events, the Constitution, and of course nature, maintain main geographical features, etc. Then on the penalty of perjury, I sign again. And then here I attached the cover letter to my exhibits, which what you seen me put in the envelope was Exhibit A flash drive, video footage from the Rise of the Moors YouTube channel of a live recorded, of live recording dated, so that's a typo, November 30th, 2019, whereby Jamal Tleib Abdullah Bey is reading from the Rise of the Moors questionnaires for all members, which state that Moors do not think they are above the laws of the United States and have no intention to overthrow the United States. Now, that's very important for me because in the police narrative, they stated that I believe that no laws apply to me. So, again, they're going to have to eat their own words. And remember, the arrest was 3/4/2020, and this is recorded from November 30th, 2019, which means I had no inclination that they were going to arrest me. So I didn't make these statements after they arrested me to try to cover anything up. This was stated before they even thought about coming to my house. So it doesn't matter what their argument is. Their entire argument falls apart. The only thing that they can do is railroad me and send me to jail based on an unconstitutional proceeding that the people are not going to stop, because the people really don't give a fuck unless it applies to them. Right? B, Exhibit B, an open letter sent to Congresswoman Karen Bass, Barbara Lee, and Mrs. Omar regarding the Rise of the Moors organization and notification of the FBI investigating us and the Rhode Island State Troopers unlawfully breaking into our home, as well as newspaper articles written about our organization with information rejecting the title of sovereign citizen and proof that we have filed claims in federal courts and honor the federal laws of the United States, etc. The full extent of the open letter may be viewed on the public information page of riseofthemoors.org, and I gave them a link. Exhibit C, scanned copy of Jamal Tleib Abdullah Bey's nationality card. Exhibit D, 18 U.S.C. 1028 with Section D3 certifying that Jamal Tleib Abdullah Bey's nationality card is valid identification. Exhibit E, the United States Justice Department's website, justice.gov, regarding Criminal Resource Manual 1508, clearly stating that 1, a driver's license is not identification, and 2, in the absence of a nationality card, there are other means of identification, meaning a nationality card is a superior form of identification, and all the forms of identification have no standing unless a nationality card is absent. F, online research of Houlihan Management and Kyle LLP. G, Rhode Island Bar search of Gabrielle R. Perlmutter, which I'm going to skip this because I already did a video on this. This is the open letter to the Congresswoman. All right. I already went over this with you guys. 13th Amendment, so I'm not going to get into any of the congressional stuff because I already did that. All right, this is the newspaper article from New Hampshire, right? I'm just going to show you this real fast. This is from the newspaper. They stated that the Southern Poverty Law Center labels the Moorish Americans as an extremist group, citing acts of violence allegedly carried out by its members. That's a label Bey, talking about me, look, they're writing about me, that Bey, meaning me, rejects, arguing the group's frequent use of the federal legal system to solve disputes, including the traffic stop in Marlboro, are evidence that Moors do not use violence to further their cause. So what is the Rhode Island State Troopers talking about? Because this is considered third-party evidence. I did not write this. This was written by Todd Bookman, December 9th, 2019. So what anti-police rhetoric is he talking about? So they're going to have to eat their words, right? And look, they even mentioned that the treaty was signed by Thomas Jefferson. And then look, from the Providence Journal, dated October 12, 2019, how we're trying to sue the Providence police for conspiring to deprive us of our rights. We didn't say go attack anyone. That's not what we said. We said, you know what? We're going to go straight to federal court because that's what we're supposed to do. So what anti-police rhetoric are they talking about? What acts of violence are they talking about? Again, look up FBI COINTELPRO, and you'll see what they're trying to do to me. They're trying to destroy my character, send me in jail, or assassinate me. Then, of course, my nationality card, which I hid my mailing location. Then, of course, 28 USC 1028 D3. All right, that's D. This is number 3, identification document. You'll see where our nationality card is valid ID pursuant to federal laws. I printed the whole page for them just in case Gabrielle All Perlmutter wants to learn something about how she's a colonist. And then United States Justice Department, how a driver's license is not intended to establish one's identity. And that in the absence of a nationality card, these other things may be used. And then Terrence J. Houlihan Jr., this is his law firm. Lawyers practicing law in Newport. So how are you sitting on the bench and practicing law at the same time? Oh, wow. Uh-oh. And then this is from the Rhode Island Bar Association. I just typed in her name, and then she popped up with her law firm. And then if you look at her Instagram, you'll see where she has a law firm with her dad. And she calls her dad her boss, which means not only are you assistant to the Attorney General, but you're also practicing law in a private firm with your father. You refer to him as your boss. So look her up on Instagram. It's not private. Don't harass her. Don't harass her. Just look it up. It's public information. Her page is not private. And you'll see where she refers to her father as her boss, which means she's working for the state and her dad. And then, of course, all the other congressional records that I've already shown you all multiple times that I'm not even going to go into. So, yeah, that's what was filed with them. We sent that Monday certified mail, which is when I did that video. So, yeah, that's it. Peace.